Great. Hey, Nora, good to see you again.
Aaron, good to see you too. Nice to meet you in person. Just wanted to thank you for your draft. And I think, we both put considerable effort into this deal and into drafting. So I think here in an in-person negotiation, if we could cover maybe some of the main topics like working capital, earn out, try to reach a consensus on those things, and as much as we can move forward with the next round of drafting and hopefully get our clients to closing as quickly as possible.
Okay, let's do it. So I think the first item you mentioned was working capital, and I know that's not something my clients had contemplated when they were talking about the deal with Natal. I think they were expecting just that they would operate the business in the ordinary course, and I know in my draft, or am I the markup? My draft, I had provided that there would be, we'll have reps and warranties that they operated in the ordinary course before signing, and we'll have interim covenants that they operated in the ordinary course. And given the nature of the business, I don't think it's very seasonable. It's been a stable business. I'm not sure why we need anything in addition to that.
Sure. Is your client willing to consider any adjustment on purchase price based on working capital, or is this kind of, a hard line that you guys have adopted? If you could give me an idea of where you stand on this.
Oh, no, sure. I definitely don't think it's a hard line. And, I'll tell you what, maybe there might be some circumstances where we could agree to a working capital adjustment, but they'd have to be very carefully tailored, drafted working capital adjustment. One of the things that's very important to my client is that at closing, they walk away with $50 million at closing. And they don't want to be coming out of pocket from that $50 million after the closing. So maybe one of the things we could do to make this look more acceptable to my client would be, instead of having us come out of pocket, maybe we have the adjustment to the working capital come out of the escrow fund. You think that would be something that we could work with?
I think it's something we could definitely take back to our client and consider. Have you considered, I guess, the flip side or the advantage to your client? I understand your client's position of wanting to walk away with $50 million in cash. But on the flip side, have you considered that by agreeing to a net working capital adjustment, your client could potentially come out in a better position should that month's net working capital exceed?
Okay, thank you. That's actually one of the items I wanted to raise. So we're talking about a two-way adjustment to working capital, right? So if working capital is in excess of a target that we agree on, we would get the additional purchase price. It wouldn't just be a one-way deduct from the purchase price. Yeah, I think that's something we can accept. The other thing to think about is perhaps if there's just some de minimis difference in the closing working capital compared to the target, maybe we don't bother each other with that, and maybe we could, I don't know what the right number is, but maybe we could agree in principle that perhaps some threshold on the working capital adjustment might be a good idea.
I think our client could definitely agree to some sort of de minimis threshold with the idea that if the working capital calculation were to go beyond that de minimis threshold, then we would have to consider an adjustment in the purchase price.
Absolutely. I think that's fair, as long as we can have a two-way adjustment. If there's a difference in excess of the de minimis, we'll do an adjustment. And again, it's important to my client not to have to come out of pocket. So if it can come out from the escrow fund rather than out of their pockets, I think this is something I can take back to my client.
I think we can definitely agree that it can come out of the escrow fund, although I'll have to get authority from my client to confirm that. I think maybe just as a show of good faith, maybe one of the other compromises that we could make is the amount of working capital. I believe that was conducted or calculated by an independent expert. So if your client wanted to also maybe do some sort of calculation of that just to confirm that our calculations are accurate, would be willing to consider that and consider an adjustment on the number as well.
Yeah, why don't we leave setting the target of the working capital to the business folks? That's just not something, I don't have sufficient familiarity with the numbers. So I hear you. We'll set, I think, an appropriate working target, but we'll let the business folks pick that number.
I agree. I think we've reached a good, positions to take back to our clients as far as the legal theories on the net working capital, and we'll let the business team fill in the numbers there.
Okay. So I think we've talked about the cash portion of the purchase price. Maybe we should turn now to the earnout piece. And I think we have a kind of a general we're in general agreement as to what the earnout should look like. But there are a few items I wanted to touch on where I was concerned about. As you know, there are going to be some improvements to the facility after the closing, and I think everybody's, at least as I understand the deal, those improvements are necessary and contemplated when the parties set kind of the targets for measuring the earnout piece. So I think it's critically important that if the improvements have been used to set the targets for the earnout, then the earnout period really can't run until those improvements have been completed. Particularly because my client, it'll be after we have sold the business, and we're not going to be in control over putting those improvements in. So I think the earnout period needs to run from the time the improvements are completed.
Our client definitely understands your concern in that regard. What we would ask you to keep in mind is that we have an ultimate goal of having the renovations done in a timely fashion, mainly because we are in pursuit of a potential client and need those renovations and modifications to be completed before we can really perform our goals for our client. We certainly understand your concern about the earnout period running from the date of closing, and can agree that that is probably unreasonable. I will tell you that our client really wants it to start at closing. And
why is that?
Our client's pushing for a start at closing, generally speaking, because he, is motivated and incentivized to get it done quickly and begin producing for his new client. And I think, with their knowledge, even though they don't necessarily have specified knowledge on your client's business, they have general business knowledge. What I can tell you is, the most authorization I have at this time is to have it start 6 months after closing. But I think based on the reasonableness of your argument, without having authority to bind my client, I can certainly take back your concerns to our client and try to see if we can get that extended to at least a year, perhaps a year and a half. I think our client's main concern is for any potential reason having to drag out the process longer than it necessarily needs to be.
And that's something we obviously don't want the improvements to, we are aligned. We want the improvements to be done quickly, efficiently, so we can realize the earnout sooner rather than later. And of course, any delay in the start of the earnout period would be a delay until the date on which we could receive our earnout payment. So we're definitely in line that we want the construction to be completed as quickly as possible. But again, my client just doesn't control the speed at which those improvements can occur. So I'm having a hard time with an outside date. Maybe what we could do is we could say that maybe except to the extent that maybe we could work on something a little softer, like except to the extent the reason for the delay in the improvements is due to a breach of a rep or warranty of the seller. Because certainly if something we told you wasn't true in the agreement, for example, if there's some environmental remediation and that's delaying the improvements, then I think it would be acceptable because that's kind of it's something that we had control over. But since we don't have control over putting the improvements in place afterwards, I think agreeing to an outside date is going to be hard for us. But I hear what you're saying. I think we're aligned. I think we want to get it done as quickly as possible. And I think we can take that back to our clients.
I do think that is one particular issue where your client's position is pretty reasonable, and we can try to talk to our client and see where we can get some flexibility on that, presuming that we are hopefully able to reach a conclusion on some of the other issues as well.
Okay. Because I think it might be more interesting for anybody listening in on our conference call, why why don't we skip over the mechanics for right now and maybe talk about the control of the business
Sure.
after the closing for purposes of the earnout. Obviously, I understand that there's a lot of opportunity here, and I appreciate the investment that your client's making in the business. I know that your client's putting in $40 million into this business to try and make it more profitable afterwards. And I appreciate that our interests are aligned, but I think there's some basic elements of fairness that I want to make sure that are going to be in place, so that there's no funny business. You've done earnouts plenty like I have, and a lot of times people refer to earnouts as pretrial, right? And we want to try and make the parameters as distinct as possible. So I think we should have some very clear post-closing operating covenants laying out what folks' expectations and responsibilities will be during the earnout period. Among those, I think we'll need to, of course, have separate books for the business. Any sort of inter-party transaction, there need to be an adjustment for that. We understand that there's a new customer coming in, but I'd be expecting your client to maximize the value of the assets, the business going forward, and I can appreciate that your client might want flexibility to manufacture different products, and I think we're willing to give you. We understand that you need the flexibility to run the business in a way that's most profitable, but if you're going to be allowed to manufacture different sorts of products, then I wouldn't want some sort of arbitrary exclusion of those products from the sorts of revenue streams that would be included in calculating the earnout. Also, I think it's important that we have somebody on the ground who's familiar with the business. We've got a great operations manager, and I would expect him to be hired as part of the process and kept on board during the earnout period. If any of those things wouldn't happen, I think probably the most appropriate remedy would be for just a liquidated damages payment of the $30 million earnout amount. So what are your thoughts on that?
In listening to your propositions, I think that there are certain elements of that our client can certainly agree to, and I think that there's some where our client's going to be a little more reluctant. I think our client's definitely willing to take, some general precautions to allow your clients to monitor the earnout. I think one of the points that you mentioned was additional product lines, and ensuring that they would go into the evaluation for the earnout. We are under the impression and agree that in basically anything that's manufactured in the new facility in the new plant is going to go into your earnout.
Okay.
So we have no intentions of excluding any products that are produced at that plant, as long as your client is willing to and understands that any products from our parent company, obviously, or any of our other affiliated companies wouldn't go into the earnout amount.
Of course.
Just basically isolated to that location.
Yep. But I assume you would be willing to adequately capitalize that location, continue based on historical spends on things like marketing and sales. So you'd be willing to say include a covenant in the agreement that you fund the business X amount of dollars over the year. Could we talk about numbers, do you think? I mean, not right now, but would you be willing to discuss with your clients kind of specific operating covenants?
I think our client fully intends to fully capitalize the new entity, and obviously they're motivated as far as wanting to achieve the acquisition of this new client. They're motivated to continue marketing operations. I would have to discuss. I know they were reluctant to agree upon a firm number for capitalization, so that would have to be something I would have to discuss with them. I understand where your client might not be comfortable with a general sufficient capitalization clause, so that may be something, if we could get independent financial analysis from each side to maybe agree on a number that may give our client more security that number is something that's achievable. But I think if we do agree on a hard and fast number, we would like to see maybe less oversight from your client on the mannerisms of the marketing or the manner in which they, conduct those business trends, just because, obviously we're a Brazilian company. We have certain ways in which we're used to operating, and we really need to have that leeway to, obviously we're going to try to maintain your momentum, but also increase it. And I think that we bring some ideas to the table that would do that. So I think in exchange for maybe agreeing upon a number, we might want to lessen the control over how we conduct those activities.
Okay. I think that sounds reasonable, and I think we've got a good path forward.
I think another point that we would agree on there is we want control, obviously, over who we want to keep on as employees. Certainly, we want to bring in our own CEOs and executives as far as, entity-wide and enterprise-wide decision-making from our parent company. But the mention of the general plant manager is definitely something that would be in our best interest to keep he or she on board as well, in order to ensure that everything runs smoothly. So that's certainly something we would agree on.
That's fine. We understand employees will be at will. It's just that operations manager where if, we'll have to think about the terms of that operations manager's employment. Obviously, he'll be your employee, but we would expect for, it's a guy we know and we trust, and we would expect for him to be in place during the earn-out period. And if he's not, then we would have to think of some remedy. And I think maybe, payment of the earn-out might be sufficient. But, I understand that this is probably a different conversation we need to have around the terms of his employment.
I agree.
Okay. Let's see. Did you have other issues with my markup on the earn-out piece? Do you want to talk about, should we talk about the metrics?
We certainly can talk about the metrics. I think in your original draft, you had potentially wanted to do a sliding scale for the earnout, and I believe that your initial calculation on the amount was done slightly different than how we would prefer. I know we had indicated, obviously, that we wanted to see it would end up being about a 9% increase in the margin, and I know that you guys kind of had more of a sliding scale and graduated payments. So, I think our client is willing to agree to some form of a sliding scale, but I think ultimately, we're pretty strong on our position that we need to see at least a 19% increase, anywhere between 18 and 19, and that's not really particularly something we're going to budge on.
Mm-hmm. Well, that's something that concerns me, because one of the reasons earnouts can be so litigious a subject is when you have these hard cutoffs, and you have a hard cutoff where it's a green light or a red light, and either you get the earnout or you don't. And I think we'd be doing both of our clients a favor is if, rather than a hard cutoff where it's a stop go, yes, no, you get an earnout payment, if there can be a range below and above where the earnout slides. So, and it sounds to me like you're amenable to some form of a sliding scale, and I just would ask that when we structure it, we do so in a way that there's not a big value difference when you hit that minimum target, because otherwise I think we're just setting our clients up for litigation down the road.
Could you clarify your position when you say above and below?
Sure. So, I think at 19%, we're talking about a $27 million payment or a $30 million payment. I don't know. Lawyers aren't good at math. And if we don't hit 19 or we don't hit 18, then how much do we get? Under your calculation, do we get zero? It seems to me like if it seems kind of an arbitrary number, and if we slide below 19 or we slide below 18, your client's still recognizing a healthy growth in the business and a good chunk of operating income. And if we just kind of flip a light switch and all of a sudden we go from $27 million to zero, I don't think that gets us there.
I certainly recognize your client's position. But one thing I think I will take issue with is the idea that the number is arbitrary. I believe we had a study done, and a lot of the other factors that I think we're basing some of these business deals on, or business terms on rather, as far as the calculation for the renovations and the projections for the increase in revenue that those renovations may yield, were based on some hard and fast facts and numbers. And I think we did do an adjustment of 90% of the projection. So I would comment that the numbers are based on research rather than being arbitrary.
Fair enough. I probably shouldn't have used the word arbitrary, but the important thing in my mind is I don't like, it's a target, you hit it, you win, you miss it, you lose. And it seems to me like we're generally on the same page, that if we do deliver that incremental value, we should get some portion of the earnout piece. So maybe we'll table the metrics and let our clients sort out that piece. But the way my clients generally see it is you're coming out of pocket, $65 million at closing, and of course with the escrow, and then there's a $40 million investment. And my client thinks they could just as easily do the $40 million investment and recognize some of the upside, but they appreciate the depth of operations that you're bringing, the new client opportunities that you're bringing. So I think there should be some sharing in the value of the business to the extent it's in excess of $105 million based on the projections that you cited. And again, my concern is I don't want to create an issue for our clients with such a big delta based on just hitting a target, but maybe we let them work out the mechanics.
Certainly, and just to give you an insight on our client's position, our client really held strong and fast to this all or nothing position, and certainly I think we can agree as legal counsel, sometimes those positions can tend to be a little bit unreasonable. So I think I think one of the most important issues to our client was a cap on the escrow, because I did notice that you mentioned, maybe increasing, a cap on the earnout. I noticed you mentioning maybe increasing the earnout if profits exceed, and obviously decreasing the amount and not having it be all or nothing. I think our client might be more agreeable to the sliding scale and dropping the all or nothing approach if we are willing to cap it at, I think, the $30 million that was suggested, with the idea that if the ultimate goals aren't reached, your client would still get some form of an earnout.
Okay. I'll have to ask my client about that. Honestly, I had thought that the $30 million payout was just kind of an example based on a formula. I didn't realize that was going to be a cap. I will ask them what their expectations are on that point and let you know.
Great.
Thank you very much.